Welcome to this video. We are in third episode of the guarantees. Here we talk about the structure and process of the guarantees. In this video, we will discuss the structure. We will focus on the three parties involved, the terms and conditions, the claim process, the guarantee life cycle process flow. We will also look at what information should be reviewed in a guarantee to ensure clarity, enforceability, and compliance. We will look at how in a financial and a legal context a guarantee can be put to use, and we will try to understand the critical components of a guarantee, and we will examine the important terms and conditions as to what we should review when we get a guarantee. Who are the parties to a guarantee? The applicant is the one who has an obligation towards the beneficiary for which he is asking the bank to step in. So, the applicant, the issuing bank, and the beneficiary are the minimum three parties associated with a guarantee. A guarantee is a contract or a promise by a guarantor towards the beneficiary. So, technically, it is between the issuing bank and the beneficiary, we can say. But it is the applicant who triggers the request. Applicant is a party who is the primary obligor. Applicant is the party who is instructing the issuance of the guarantee. Applicant is the party who requests that the guarantee from a bank or a financial institution be issued in favor of the beneficiary. He could be a contractor, a seller, a supplier, or any entity, and he is the one who has a duty to provide assurance to the counterparty. Applicant initiates the application process. Applicant bears the liability if the beneficiary makes a claim. Applicant is required to provide a collateral and pay the fees to the issuer. So that is an applicant, the party who requests the guarantee from the bank. Now comes the beneficiary. Beneficiary is a party in whose favor the guarantee is issued. Beneficiary is a party whom the guarantor protects. Beneficiary could be a buyer, an employer, a client, or any entity who requires an assurance. Beneficiary is a party who could suffer a loss for which they want the cover in the form of a guarantee. So, beneficiary relies on the guarantee as a form of security or an assurance. Beneficiary can make a compliant claim or demand to trigger the payment under the guarantee. Beneficiary ensures that the guarantee aligns with the underlying contract so that their claim will be compliant. Beneficiary has to make sure that the type of guarantee and the text of the guarantee is what they expect to cover their potential loss. Then comes the issuing institution, also called as issuer or guarantor. The guarantor or the issuer is the bank or a financial institution who issue the guarantee on behalf of the applicant. The issuer assumes the responsibility of paying the beneficiary against a compliant demand. Issuer is irrevocably bound to honor the claim. Issuer reviews the applicant's request and ensures the collateral is adequate for issuance of the guarantee. Issuer ensures that the guarantees are as per the current compliant guidelines or regulations. Issuer also ensures that the claim is compliant before payment is made. The guarantor is primarily responsible to the beneficiary, but the guarantor has a right to claim reimbursement from the applicant. So these are the main three parties. Looking at the terms and conditions of a guarantee, what are the key elements? The guarantee amount. It is a maximum amount which is payable under the guarantee. It determines to what extent is the guarantor liable to the beneficiary. It is the level of security that the beneficiary can depend upon. A performance guarantee for $500,000 means the beneficiary can claim only up to $500,000 irrespective of the loss that they may suffer because of the failure of the applicant in the underlying contract terms. Then we look at the validity period. Validity period is the duration during which the guarantee remains enforceable, the period during which the guarantee is live or valid. It is usually from the date of effectiveness to the date of termination is the validity period of the guarantee. So this the beneficiary has to ensure this aligns with the timeline of the underlying contract because claims can be lodged only during the validity period. It is a timeline during which the guarantee remains active for the beneficiary for lodging the demand. Then comes the conditions for payment. Is the payment conditional? If so, what are the conditions? Or if there is a requirement for a document, what document, issued by whom, in what format, in what language, that the beneficiary should look for in a guarantee. The conditions specifies the circumstances under which the beneficiary can trigger a demand or a claim. When can the beneficiary ask for payment and have the guarantee enforced? For example, the payment guarantee will say there should be evidence of shipping or movement of goods in favor of the applicant. So this is it. Then let us have a look at other aspects. The more critical terms is the jurisdiction and governing rules. In case the guarantee is not paid by the issuing bank, in which court you can file a suit. The suits that we file will be subject to which courts of law. Is there any other rule or regulation that applies to the guarantee? For example, Uniform Rules for Demand Guarantee 758 or International Standby Practices 98, etc. So this provides clarity as to how disputes, if any, will be resolved between the beneficiary, the claimant, and the guarantor or the issuer. Then we have amendments and termination. The amendments and termination clause will provide an procedure to be adopted in case a guarantee is to be amended. If it is silent, every amendment will require beneficiary consent. Some guarantees may have an auto reduction clause. That means advance payment guarantees will keep on reducing in their value based on the performances made and certified. This prevents unintended liabilities and also conclusion or concession to the parties to ensure the guarantee life cycle is in sync with the underlying contract. The currency of the guarantee is also important because the currency and amount decides up to what amount, in what currency payment will be made. Currency is the currency in which the guarantee is denominated, and that is the currency in which claims can be made, and that is the currency in which payment will be made. This is important because this will help us avoid confusion in case of a cross-border transaction. There is no currency fluctuation risk unintentionally passed on to another party. Let us look at the claim process. The claim process outlines how the beneficiary can make a demand under the guarantee, how the written notice of default or non-performance is required, and what other certifications are required by the beneficiary to trigger the payment or claim or demand under the guarantee to get it enforced and get the funds realized. What are the steps? First is beneficiary submits a notice that the applicant had defaulted. Then the beneficiary also has to ensure the demand so submitted is in compliance with the terms and conditions of the guarantee, maybe the format, maybe the language, maybe the amount, maybe the dates, maybe the text. Maybe there could be requirements of submission of additional documents, like maybe original guarantee should be submitted, or maybe copy of the shipping document should be submitted, or maybe copy of the unpaid invoice or a demand that has not been met that was submitted to the applicant will have to be submitted. So such required documentation should be looked at. These documents provide evidence that the beneficiary is eligible to enforce the guarantee. Missing or incorrect or incomplete documents may lead to discrepant claim and delay or denial of the payment of the claim. Then the issuing bank or the issuer or the guarantor will review the claim to ensure that it is in compliance with the URDG rules or the terms of the guarantee and other conditions that needs to be met. Then the payment will be disbursed. The claim will be settled and payment will be made by the issuer to the beneficiary. Subsequently, issuer will claim from the applicant. Let us look at the process flow. First, the buyer and seller, the applicant and beneficiary agree for a contract in which one of the requirement is a guarantee. It could be a performance guarantee, advance payment guarantee, retention guarantee. It could be anything. Sometimes you may have a situation where a tender notification is sent out saying along with the bid you have to submit a tender guarantee. So the applicant requests for a guarantee from their bank. The application includes the details of the guarantee, including the maximum amount allowed, maximum validity period, what are the other terms and conditions, when the claim can be triggered, how the claim should be, etc. The issuing bank or the issuer will validate this information, and if found acceptable, will issue the guarantee and deliver the same to beneficiary. The moment the guarantee leaves the control of the issuer, then it becomes irrevocable and enforceable. Sometimes advance payment guarantees may have a clause that the guarantee will be effective only upon receipt of advance payment in the account of the applicant with the issuer. So till such time the guarantee is not effective. That means till such time claims cannot be lodged. Now how a guarantee can be executed? If the applicant defaults, beneficiary can submit a compliant claim to the issuing bank. The issuer or the guarantor will process the claim if it is compliant and disburse the payment. So as a part of application, there is a standard application. The terms and conditions of the guarantee needs to be set, what currency, what amount, what date, what trigger, etc. As a part of issuance, bank will include their own terms and conditions applicable to a claim that will be paid under the guarantee to be compliant. Then as a part of execution, beneficiary has to ensure the requirements of the guarantee, the requirements of the URDG are properly met and there is a default as per underlying contract, so that the claim will be compliant and settlement will be smooth. What are the features or characteristics of a guarantee that one need to look for or ensure when you receive an instrument? What specific information is of critical significance to ensure effectiveness and enforceability of a guarantee? First is the guarantee amount. The amount should align with the requirements of the underlying contract, including the currency, so that there is no fluctuation or a translation loss, so that this covers adequately the potential loss that you foresee. You have to verify whether the guarantee is for a fixed amount or a percentage, and if it is a percentage, you need to know how and when it might vary. Then comes the validity period. This period should match with the timeline of the underlying contract, and you should also check for provisions for auto extension, auto renewal of the guarantee. Is there any evergreen clause? Is there an auto reduction clause? And at what time this will be extinguished? One should also look for the payment triggers, that is the conditions under which the guarantee can be claimed by the beneficiary, the terms that the beneficiary has to meet, and whether it is clear as to when a demand will require additional documents in the form of proof of default, or is it a simple claim, or whether the original guarantee has to be returned. What are the document requirements? One has to look for whether the guarantee calls for any additional document along with claim to make the claim compliant. So this could be evidence of default by the counterparty. Let us look at a case study. Now suppose a multinational engineering firm is awarded an infrastructure project. Then at the time of bidding, you will need to have a tender guarantee. Once a contract is received, the contractor will have to submit a performance guarantee of 10 to 20% in favor of the agency that awarded the contract. This performance guarantee has to be valid till the project of the contract and then some extra warranty period. The trigger for the performance could be non-performance by the contractor, which could come in the form of non-submission, non-release of the work completion, progress certificate, etc. The claim could be in the form of a written notice of default that was been already served on the applicant along with the evidence of non-performance mentioned over there. In case of an advance payment guarantee, then it should match the amount of the advance received, usually up to 20% of the guarantee value, contract value. And then this will be valid till, for example, delivery of goods or services, that is a full contractual period. The trigger will be failure to deliver the goods or services will cause or give rise to the right to the beneficiary to claim. And documentation would be non-delivery or notice of default. What is the outcome? There is no trust between the parties before, but because of the existence or a guarantee coming into picture, they have enhanced trust to deal with each other. Because this will mitigate the financial risk that they may encounter. This will also facilitate financing of the project, and parties will be able to comply with the requirements of the underlying contract. What are the common pitfalls to avoid in case of a guarantee or a claim? When dealing with guarantees, parties often encounter several problems at the time of issuance, while drafting the text, at the time of claim, due to which claim may not get paid. That is, the effectiveness of the guarantee or enforceability of the guarantee gets diluted. One reason is vague and ambiguous language, because this can lead to dispute or delay in the payment. Second is missing the deadlines, claims not met within the validity of the guarantee, or documents are incomplete and incorrect, or the contents of the documents are invalid, or the guarantee itself is confusing, so difficult to enforce. There could also be issues like the currency mismatch between the claim or a wrong document being submitted and other discrepancies. This could lead to issues in the cross-border usage of the guarantee. So understanding the process, understanding why it is necessary to have the guarantee effective and enforceable for the benefit of the beneficiary to claim whenever things go wrong. Understand what are the roles and responsibilities of the parties like applicant, beneficiary and the guarantor, and reviewing the critical elements of a guarantee like the amount or the currency or the terms or the documents will ensure the buyer and seller will be able to navigate by mitigating the risk and facilitate cross-border trade. Thanks for watching this video. We shall catch up again in another class.